Welcome everyone to this webinar. We very much appreciate your presence, and today's webinar is organized by the interest group on international courts and tribunals within the European Society of International Law. My name is Machiko Kanezake, and I coordinate the interest group together with Yusra Sueri, Cecily Rose, Mike Becker, and Stefan Wittig. And Yusra and I would moderate this event. So today's webinar is to talk about mooting, and we have decided not just to talk about it, but to critically reflect on moot court exercises that international students and teachers have invested in for many years. And we can imagine that many of the participants in this webinar have been involved or interested in getting involved in international law mooting as a participant or as a judge and as a court. And indeed, mooting is a very popular thing in international law. Apart from the well-known Jessup competition, moot courts have been set up in the fields of human rights, international criminal law, trade law, investment law, space law, and law of the sea, just to name some of them. And there is no doubt that mooting has a lot to offer. It helps students and other participants to develop their vocational and analytical skills. They also learn how to work as a team. But there have been some concerns that something important is missing here. And one of the questions we would like to ask is whether we are investing so much energy to reproduce existing structural inequalities embedded in international law. So we, interest group members, decided to organize this webinar to help us sort of reimagine international law moot court exercises. And for that, we invited 5 panelists who have voiced their critical views in different venues and platforms on mooting in international law. So we are very curious to hear their thoughts on whether and how mooting can be used as a tool for critical legal pedagogy. So I will first like to invite the screen to give the screen to Christine Schobel-Patel and Fine Hartmann. So Christine is associate professor at Warwick Law School, and Fine is an LLM candidate at Vrije Universiteit in Amsterdam. So Christine and Fine, you have the floor.
Thank you so much. Thank you, Machiko. Thank you, Yusha, for the kind invitation. And it's really great to have a forum to discuss these questions of rethinking mooting that, everyone in the room has perhaps considered. So in my own work on teaching critical and critical pedagogy, I've been thinking about ways in which to combine theory and praxis in the classroom. And so as part of that, I thought it was really important to consider how the courtroom is presented to students, and also how it can be radically imagined and reimagined. So in really a very, very brief overview only, I wanted to talk a little bit about the trial of rupture concept that I've been using with my students, and then I'll say a little bit also about the experimental mooting that I've done in collaboration and really with a lot of energy put in by Wouter Werner, who I think is also in this virtual room. And Fina Hartmann was one of the student participants, and so I thought it would be a really great idea to invite Fina to say a few words about how she experienced the experimental moot from the perspective of a participant. So I start off from the premise that regularly law students don't often encounter the courtroom as a political space, or that the politics of the courtroom is sanitized somehow. And that is certainly what's reflected in the Jessup or the Telders moots, which sort of solidify that idea of the courtroom as an apolitical space. And apart from being problematic in its own right, that the politics of liberal legalism itself is hidden, it also arguably is even further divorced then from the lived experience of lawyering, which is something that Walter Werner has emphasized, and I think quite rightly. And something that we have been concerned about is the aspect of the competition when it comes to mooting, which further distances participants from the particular individual group or community that is represented in the courtroom. So, trial of rupture and radical mooting. Now, this is an exercise in really overtly bringing politics into the courtroom, and to ask the question, what would it look like? What would a courtroom look like if politics is made explicit? And I started several years ago with exercises in my international criminal law class on trials of rupture, which I did alongside other simulation exercises. So mooting I see as one of these simulation or role play exercises, and I do them also on the UN Security Council and the UN General Assembly, because I think as a tool of pedagogy, role play is really useful, and we can talk more about that in the Q&A. So one of the guiding questions then is for the trial of rupture is, how does a patriarchal system represent itself in the courtroom? How does a Western dominated notion of justice represent itself in a so-called international courtroom? And what are the class aspects that are hidden behind language and dress and symbolism in the courtroom? So this is really thinking about, how do marginalized groups often experience the courtroom? The thing about radical mooting then is that it takes real world problems and makes them visible in the courtroom, rather than saying to students, as I think law teachers feel that they have to do, is sort of leave your politics outside of the courtroom. This really encourages them to bring them into the courtroom. And I have been looking at Rosa Luxemburg, and who was a revolutionary who was incarcerated many times, was in the courtroom many times. She and her, at the beginning of the 20th century, and she and her lawyer, Paul Levy, they conceptualized this trial of rupture, where they tried to flip the courtroom, where they tried to bring the politics that was happening outside of the courtroom into the courtroom. And that's also very much in line with Jacques Vergès' anti-colonial lawyering. Again, we can say lots more about these individuals in the Q&A. What I think Rosa Luxemburg and Jacques Vergès share is that they had realized the role that media can play. So radical mooting is also an exercise in thinking about a broader audience beyond the judge who is on the bench. So I recently did this simulation with students at the Rosa Luxemburg Foundation. And so I first introduced Rosa Luxemburg, and I have to say these students were not all law students. In fact, the law students were in a minority. They came from all sorts of different disciplines. And I first introduced then Rosa Luxemburg and her trial. So I did a little bit of history on that. And then I encourage students to think about structural violence, what that means to them and how they have experienced that. And they spoke about capitalism and patriarchy, police violence, racism, and so on. So that sort of sets the frame as a person, Rosa Luxemburg, and then the structure of violence. And then I split the students into groups, random groups of defense, prosecution, and there is also then a defendant. I was the judge, and then I invite them to do to prepare a short presentation for the Moot. And they switch sides at some point, and then there's a feedback session afterwards. And I think it works really well on multiple levels. The students really engage with this role play element really well. And it's a great reflection to think about what is it about the courtroom that is often naturalized, what is allowed to be in the courtroom, what is usually not allowed to be in the courtroom. So finally, then on the experimental Moot, and then I'll hand over to Fina to say a few words. Walter Werner and I had thought that we could conceptualize a mooting exercise that doesn't have this competitive element to it. They can choose to do a trial of rupture, but that's not obligatory. So that's why I sort of distinguish between the trial of rupture and the experimental mooting. We had last year students from Rwanda, Zimbabwe, Suriname, China, Indonesia, the Netherlands, and the UK. So a majority of Global South students, which also I think was an interesting dynamic for speaking about colonialism and how that has a role in the international courtroom. And there were real cases. So in the first year we did the Bashir case, and last year then the Coney case. So it's asking sort of what happens if we take the competitive element out? What happens if, rather than in mooting, students are encouraged to sort of identify with their particular law school? What if we mix teams so that they don't represent a particular law school? And then what if they think differently about audience? So we have not only the courtroom simulation, but we also have a simulation of a press conference at the end where the participants are invited to think of a hashtag campaign. How would they present this to the press, to a wider public? What does that do with the legal arguments, and what does that do with the politics? So yeah, and that's all from me as some sort of provocations almost of what can be done of rethinking mooting. And then I'll hand over to Fina.
Yeah, thanks a lot, Christine. And Fina, sorry for mispronouncing your name earlier.
Thank you very much. It's great to be here, and it's great to share the student perspective. Yes, so I would like to highlight some of the main elements of the Moot Code that really, made a mark on my legal education. So the first is that we had prep sessions, so introductory sessions before the actual Moot Code happened, and that was with different academics from different fields of academia, and they shed light on different aspects of criminal justice and on trials in general. And for me, that was really a moment where I first started to think critically about the ICC, and it was great because I think, in contrast to normal Moot Codes where you only have your own coach, we really had different people talking about the same subjects or slightly different facets of the same subject, but from completely different angles, and that was really really great for me. And then, as Christina mentioned, we had international teams. I think that was great as well, on the one hand, because we had to deal with different mentalities, with different attitudes, and it's just a great conversation starter, simple as that, if you're in the same team. But at the same time, I felt like that cooperation was a bit difficult as well, so that we had some administrative problems with the visa for some of my team. And also in my team, there were people from the Netherlands, from Suriname, and from Indonesia. So that's just a huge effort to bring them together before the day to actually prepare your speech, just because of the time difference. And yeah, but still, it was a great, yeah, as I said, a great conversation starter. Then we had the possibility, so we had 2 days of mooting and 1 day of the press conference. And during those 2 days of mooting, we could do essentially the same, the same play, the same moot twice, or we could completely change our structure, our strategy, and reproduce what we've done before in a different way and present it in a different way. And that was nice as well, because we, after the first day, we had a reflective session and we just talked a lot about our different strategies. And that's really where the non-competitive element kicked in, because I think because it was not competitive, we could easily just talk in different teams and adapt and copy some of the strategies of other teams if we felt like that was nice and we didn't feel bad about it, and no one was worrying to share any of their strategy or any of their views. And then we had the press conference on the final day, which was also very new for me, because I'm normally not really into social media or not really into like press at all. So for me, it was really challenging to think about a legal argument in the way that it would be picked up by the press, and also to think about the keywords that the press will pick up, about the headlines that the press will make. And that was a completely new experience for me. Overall, I think it was a great experience. I think I really radiating that, especially on the intercultural aspects as well. So perhaps to have a final anecdote to tell. On the last day, we were really close as a group, and we sat together in a bar. And one of the girls from Rwanda actually said, "Oh yeah, next time we do this session, we should do it in Rwanda, and we should do it about the Rwandan genocide." And I was really astonished in that moment. And then her fellow from Rwanda said, "Oh no, they wouldn't let you do that." And so we really kicked off that discussion about the politics of the trial and the politics even of the moot court. And it was for me also the first time that I had a conversation about the Rwandan genocide with someone from Rwanda. And that was such a huge experience, because before that I had only spoken with academics about the genocide and not with people from there. And in such a setting and with such a start of the discussion, that was really incredible. So that's all from my side, and happy to share more in the Q&A.
Yeah, thanks a lot, Christine and Fina, for giving us the context about mooting as an exercise, and also give us some specific examples about how this exercise can be organized in a different way. And just for the audience, the experimental mooting that Christine and Fina have talked about is discussed, explained in one of the writings at ESIL Talk. And we also created a link on the program. So I think a lot of people would be interested in reading about it. And thank you so much, Christine and Fina. So now I would like to give the screen to the next speaker, Dan Joyner. So Dan Joyner is a professor of law at University of Alabama, and he's a director of international programs. Dan, you have the screen.
Thank you, Machko. Hello, everyone. My name is Dan Joyner, and I'm sort of increasingly wondering why I'm here. Because I don't, I've been writing about nuclear weapons for the last 20 years. That's what I do. But I think I'm here because of one rant that I wrote in 2012 flying home from Chicago after my law school's Jessup team competed in a regional competition. And I had just had it. And so I wrote this thing on the plane and I published it on Opinio Juris. And it's funny, it's become one of my most popular works of writing, even though it's really not scholarly. It was just a reaction I had. And I guess that's why I'm here, to sort of talk about my experience as a faculty advisor to a Jessup team. And I have been doing that for 16 years now. So my remarks will be specific to the Jessup competition. You know, my remarks then were pretty critical of the Jessup Moot Court competition in terms of its structure and all of that. I won't try to summarize it. I guess, though, you could sort of boil down, and I will say I have continued to coach my team at the University of Alabama ever since then, although what we've done in the years since is divide responsibilities, and I now coach the team as they are preparing their memorials. I help them identify issues of law, help them research, I help them sort of understand the substance and help them understand their arguments. And then I hand off to another member of staff who is an expert on oral advocacy, and he then helps them with their oral advocacy skills. So I think I actually have kept my promise in that piece to never be in the room when my team argues again, because it was just too stressful for me. You know, what were my concerns about the Jessup? Well, for one, it really doesn't look anything like what it's supposed to be showing, oral advocacy before the International Court of Justice. It actually bears pretty much no resemblance to oral advocacy before the International Court of Justice, in my experience, at least in the United States. You know, you have in the Jessup competition, as I've experienced it, so many of the benches of judges are just irritatingly active and pouncing on students and you know, all over them with questions. And obviously that's, if you've ever watched oral argument before the court, that's not at all how it works. In fact, I think the Jessup seems to have been structured more like a US federal appeals court, which it does kind of look like at times, depending on the bench. So what I mean by that is I'm not sure exactly what I'm teaching my students to do when I'm teaching them to do the Jessup, because I'm not teaching them to appear before the ICJ. So I don't know what I'm teaching them to do. So that's a trouble for me, sort of pedagogically. Then, as I said in the piece, you know, I have a problem. I have had a problem with, and again, my experience is specific to the United States, the regional competitions that are held in cities across the United States, and the ones that I've been at, New Orleans, Orlando, Chicago, you know, they draw on the local bar, the local attorneys for judges who, and they're very kind and volunteer to be judges, but not that it's their fault, but they don't know a lot about international law. And so it's hard to know exactly, again, what am I training my students to do if they're standing up there and they're supposed to be making public international law arguments, but the judges don't know anything about international law. So it's, as a professor, pedagogically, it's hard to know what I'm supposed to do here. So what I've done over the years is I've tried to, I'm sure I'm misstating this, misrepresenting it, but come to sort of more of a Zen position where, all right, these are my students. I'm going to teach them to the best of my ability how to identify issues of international law, how to analyze, use the best analytical methods I know how to apply law to facts, help them to structure arguments, and then sort of sit back and let the chips fall where they may. Because in my experience, the actual competition is more Russian roulette than anything. It's completely random in its outcomes. So I've tried to do that, and that at least has helped my blood pressure over the years. I do, and that's not to say that my students don't get anything out of Jessup. I've never said that. You know, I think that going through the Jessup competition does help them with their oral advocacy skills, standing up in front of a judge, making arguments, getting questions. I don't think that would help them before the ICJ, but since my students are American law students, they may well be before a federal court of appeals. And so these oral advocacy skills might help them. I also feel that I am teaching them, to the best of my ability, substantive international law on the issues presented and skills of legal interpretation and application. And I think that those are universal skills, at least the interpretation application. And of course, if they happen to end up in some job that uses international law, I feel that I've prepared them. So I feel I've done my duty pedagogically for my students. And I feel that they get something out of it. It's just not maybe what the Jessup thinks they're getting out of it, or purposes them to get out of it. I want to say something about what Christine was talking about. Although I do not write in critical legal theory at all. I will say that I'm a formalist, a sort of a self-described formalist, and the idea of a court as an apolitical space actually sits well with me. I'm one of those who is a formalist and who thinks that law ought to be something other than politics. I know that is a fraught assertion, but I think that that's what law should be. And so to the extent that, and I'll make myself the sort of critical object of criticism, that's fine. But to the extent that moot courting does sort of require students to reify formalism, orthodox substantive international law interpretation application, that actually doesn't bother me, because I think there is a place for that in the world. I think there's a place for theory. I have a master's in political science. I often apply, well, used to anyway, apply international relations theory to my work. So I'm not a stranger to theory when it comes to international law, but I don't suppose I see a ready application of that in mooting. That's my opinion. So I'll stop my prepared remarks there.
Thank you so much, Dan. I think I can imagine that your feeling is maybe shared by quite a lot of participants who served or willing to serve as a court. We see a great benefit in mooting in international law, but at the same time, sometimes the setup does not really structurally allow the way student engagement in the manner that you might wish to see. So thank you, Dan. And Dan's writing is also listed in the program, just for as a reminder. So I would like to give the floor to two speakers. So the first one is Abhijit Sharibastava. He's a law student at Jindal Global Law School. And at the last but not least, Rudolakush Lakura. He's also a law student at Jindal Global Law School. So you have the floor.
If I may take the liberty to begin by quoting my coach and Professor Raman, may it please no moot court. Today I am joined by my co-author and my past teammate for 3 years in the Jessup, Rudraksh Lakra, and we are going to address 2 large points in which both of us have shared experiences. I will address you on the Jessup specifically, much like Professor Dan, because we have only participated in the Jessup. And I will speak of structural problems with respect to the atmosphere and the milieu of the Jessup and the institutions it represents. After this, Rudraksh will take the floor and he will speak of the possibilities for critical sensibilities that do exist even within that milieu, despite the challenges that I am going to highlight. And why we do so is, although it is important as to have a conversation of this nature, to pursue critical pedagogy and any perspective of that kind through moot courts. We feel that it is also important to acknowledge the limitations that come with that format. As any critical scholar who thinks of mooting as a pedagogical tool would agree, mooting is perhaps not the best suited tool for pursuing critique. Nonetheless, it has possibilities for critique, and that is how we want to tailor our perspective today. And at the outset, like the other speakers, I want to clarify the position where our perspective comes from. Uh, we, as in our reflection, which will be listed in the theme of this program, we come from a third world perspective of international law. And that reflection was tailored around citational biases that we encountered in our experience, where state practice, scholarship, and arguments from the global north, so to say, were given somewhat of an automatic preference during our national as well as international rounds, in the sense that these were arguments where these were intuitive to the audience to which we spoke. The judges, of course, are trained in the mainstream of international law. And when we speak of the mainstream as of today, it is the North-centric understanding of how international law is passed down and handed down. And when we say so, and we detail this in the reflection, so I will not spend much time on this today, we did encounter instances where we had practice from the South, from uh, authors or states that are not discussed in mainstream scholarship, where we found it difficult to engage judges on those arguments, and therefore we eventually strategized against the use of those arguments. And that was somewhat disheartening for us. But at the same time, I want to highlight that from our perspective, uh, while we do look at the court as a political institution, we do not feel that there is a dichotomy or there is a necessary exclusion between seeing the court as a political institution while at the same time trying to learn how it ought to work, were it a formal institution, were it apolitical. And I say this to mean that through the JESA, we did learn the mainstream practice of international law. We learned, but perhaps not entirely accurately, how things work at the ICJ, but at least in terms of what the JESA represents, we were able to strategize and exclude arguments that we felt would be unwelcome. And therefore, there was a consciousness of how uh, what that milieu means, what that expects, and what that embraces as citations, as arguments, and as persuasive legal thought. Nonetheless, we feel that the recognition that this environment of the JESA particularly, that it had its own politics, that it had its own problematic legacies, that in fact helped us navigate this space were it a formal institution, were it under a pretense that everything is fine and that there is no such prejudice or bias in terms of the arguments or the persuasion. And I say this because at the end of the day, uh, we were always told by our coaches, by our judges, and by fellow participants that when we enter a moot court round, our main priority has to be to convince the judge. So an understanding of the politics of the courtroom, of where the judges come from, for us, strategically, it was beneficial to have that consciousness, even in terms of only winning the round, were it to say. And to conclude that first uh, reflection from our end, I would only say that for future mooters who are watching this, or for any coaches, simply because students engage in critical legal thinking or want to pursue critical pedagogy through a moot court need not mean that they are not focused on winning, or that they will be less inclined to win or less capable of winning the moot court. Rather, these can be conducive to each other. Now, before that, however, before Rudraksh comes to how this can happen, how we can generate critical sensibilities within the environment of a moot court, I want to address another structural problem within the design of at least the JESA, which is classism. Classism in the sense that the JESA has an expensive registration fees. Although it is an international moot court with over 100 countries represented, even from those countries, including Rudraksh and myself, we are the elites among the elites because we have access to travel funding. We have access to the right faculty. We have access to the right resources such that we are able to participate in as prestigious and classist a space in the first place. And I do not intend this as an aspersion against the JESUP community. Of course, organizing a moot court of this scale will take funding. It will take a lot of institutional resources, which have to come from somewhere. And this is why I term this as a structural problem. But at the same time, if we are to think of critiquing moot courts or of pursuing critical sensibility through moot courts, we need to ask ourselves, for whom and who is doing the critique there, and where is the critique coming from, and what is to be made of that critique after the moot court. And for that reason, I certainly feel that problematizing ourselves as participants in the moot court, whether we are students, whether we are judges, whether we are coaches, that will help us to make the JESUP a more inclusive space. Or even when inclusivity cannot be guaranteed, to at least be aware of that fact so that we know that something has been missed out and that moot courts cannot guarantee critique in its entirety. Now, as I said, what do we make of moot courts afterwards is something that most critical scholars today who are engaging with moot courts in their reflections, including those on this panel, have begun to think about. And I want to quote a specific excerpt from, once again, my coach, Professor Raman, which is to ask, critique is not just, it is the question we ask ourselves should not be to only see whether we can find critical pedagogy in moot court, but whether after having pursued a moot court, we can pursue critical pedagogy in the future. For most of us, including myself and many others, especially from those in India, the JESUP is in fact our first entry into the atmosphere and into the institution of international law, and our first introduction to the aesthetics of the international legal system. And of course, there is a lot of unlearning to be done through critical theory afterwards, because it has a very specific style, as I said, of lawyering and of representing what is the international legal system. It nonetheless offers us the possibility of that critique because it is what introduces us to the system in the first place. And this is something worth pondering about, because as I participate from the JESUP as an Indian student with Rudraksh, as others participate in the United States, and yet others participate from states like Kazakhstan, South Africa, from different continents and different cultures, the JESUP does not mean exactly the same thing to all of us. And because international law itself as a system and as a discipline is perceived differently, engaged with differently in all of these cultures and countries. Capacity building is not the same in all of these milieux. And in that sense, at least in India, as we see from the reflections of Professor Rohini Sen particularly, international law is often seen as, I see Aman in the chat, and it's wonderful to see that you're here. We see that international law is treated as somewhat of an exotic discipline, which is that international law exists far away in cities like Geneva, New York, and so forth, and not in New Delhi. And therefore, it is only worth engaging with for those who want jobs there, as opposed to a language that can help us in the localities here. And therefore, when we think of the JESUP, we must also think that for countries like ours, it helps with capacity building. It helps even create the possibility of thinking critically about international law in the first instance, because it acts as our entry into international law. But to be aware of this fact then, especially for those of us from the global south, it becomes our responsibility to make sure that our learnings through the JESUP are put to productive use. And to that end, I now defer to my co-speaker Rudraksh to talk about how this can be done.
I hope I'm audible. Yeah. I shall be continuing the submissions of my co-agent today. At the outset, we would like to clarify and make two primary observations. First, we would like to clarify that we take for granted that mooting can be used as a tool for promoting critical pedagogy. Many scholars, including critical scholars from the global south, have written about this potential, often basing their work on their personal mooting experiences. However, we remain mindful of the potential limitations of mooting as a pedagogical tool, and we return to this note at the end of my observations. And the second preliminary observation is that we also take for granted that the experience of participating in international moot also has a role in forwarding the streams of scholarship that looks at international law critically. We understand that to critique the mainstream, one needs to understand the doctrines of the mainstream. Similarly, another example is that mastering what Christine refers to as an ideal type advocate style is a helpful tool for strategic litigation for those at the margins. To build upon this point, I'd like to use a quote from Atta, who has written for Twiler, who says that Palestinian students have to learn to consciously shift between multiple consciousness to be able to learn to make a positivist claim for survival and in pursuance of political strategy, and also be critical of international law that has over the year done disservice to Palestinians. Based on the above two mentioned claims, we believe, and this is our central argument, that the question should shift from if mooting can serve as a generative space to the question of how can we maximize the potential of mooting to serve as a generative space for creating critical sensibilities. And this requires us to think in concrete and strategic terms of how this space's potential can be maximized. Within this space, it is our opinion that the primary responsibility falls upon the stakeholders, the people who coach moot court competition, the teams, the people who assess teams, and even the members who take rounds for teams, for them to nudge teams towards the critical. And this has to be an ongoing and active process instead of passive that requires constant interventions. I think that this can itself require multiple strategies that one can take forward. We want to list some which could concretely be used by teams for forwarding critical sensibilities within a moot. First, based upon the piece by Scott and Sorelia, who have argued that coach in early preparatory sessions of a moot in the start can refer teams to critical texts or introduce them to critical perspectives. I think that that conversation needs to center around the fact about how critical sensibilities can be used to help teams with their preparations. If we make a pitch in a way that connects to the interest of the team, then there will be a greater purchase to the central idea. Second, I think, and this is something which I think I've not seen reflected within literature, is the idea that constantly the coach should help students reflect on their positionality and where they're coming from. For instance, for us, that was that we came from a third world country. We came from a developing country, and what that meant to look at the law in a post-colonial country, to look at certain laws and human rights issues, for example. So this is part of an ongoing engagement and constant nudges. Third, I think the another aspect is that coaches should try to help him understand the policy consideration behind an argument, which can be rooted in politics, economics, or sociological concerns. And this can address the issue of the impartiality of law. Especially in JESUP, legal issues have underlying rich factual themes, which can bring into fold the political. For instance, we were recently, Abhijit and I were recently taking a team of a Indian national team, and they were arguing on the unable and unwilling doctrine, and they were arguing as a state that argues that the unable and unwilling doctrine shouldn't exist within international law. And we recommended that instead of only looking at the question from the question of is there enough state practice for this doctrine, why don't you also include a policy perspective of why we shouldn't have such a rule within international law? And that brings into fold the rich tapestry of criticism that has been given by critical scholars from the global south of the unable and unwilling doctrine, which has been used to abuse and has been abused often against states on the global south. Fourth, I think another useful practice that our coach Aman nudged us towards following is to include a more regional diversity of sources when you're citing sources. This could moving from the ICCPR, the Human Rights Committee, the European Committee on Human Rights, to, for instance, the African Court, the American Court, and include these kind of practices. Similarly, for customary international law to make the arguments, you can have a state practice from 5 regional groups within the United Nations. So have a rich tapestry of these sources. Fifth, we often see that teams don't read separate opinions, but reading them might offer a rich tapestry of critiques to the mainstream, and they can be very helpful for policy-based arguments, such as the opinion of Veera Mantri, for instance, in the nuclear weapons opinion. Now, moving towards concluding my submission, and sort of methodologies that I've recommended, these are merely certain things that we list, and I think we engage every single coach and team to constantly engage in this process, think of other methodology through which critical pedagogy can be nurtured within the mooting. In the concluding observation, I'd like to note that despite our optimism with respect to mooting, we still believe that there are certain limitations with respect to the extent to which mooting can promote critical sensibilities. And with this, we believe that there are certain alternative critical perspectives that the mainstream international law just cannot provide the vocabulary for. For instance, when I was coaching a team for the Stetson Moot in 2021, the moot problem linked to bad conservation. And in environment law, often the issue is regarding transboundary harm. And transboundary harm always has to be looked in the contemporary scientific evidence. but the contemporary scientific evidence of how to carry out battle conservation completely excludes the possibility of relying on indigenous resources of how bat conservation is supposed to be done. Even though in Latin America, bat conservation has been carried out in a huge numbers, and that has been based upon indigenous knowledge systems. So these indigenous knowledge system and their perspective is something that's completely sidelined. And even briefly mentioning the post that we had written post our dress up was about the idea that it's certain legal arguments that we wanted to make regarding decolonization was something that we couldn't make within the mainstream because we knew that it would not be persuasive to the judges. We hope, and I conclude my submission, we hope that these insights contribute to this rich conversation.
Thank you so much, Abhijit and Radhakrishnan. I think one of the key elements of the moot court setting is to convince the judge. So some of the critiques and uncomfortable elements that you have experienced through the actual, the occasions where you participated in moot court competition is also connected to some of the issues that Christine and Wouter have tried to address in their experimental mooting. So thank you.